is still present, very kindly told me that there would be no point in anyone staying around to hear my paper on FIRA opinions. He then went on to say that the reason was that FIRA opinions have been replaced by rulings given by the agency. Needless to say, I am not in a position to agree. However, I do agree that the existence of the agency and the fact that rulings are given under FIRA are major considerations affecting the giving of legal opinions about FIRA. I just want to mention briefly some background about the Act for those who may not be very familiar with it. Under the Act, a foreign-controlled investor, referred to in the Act as a non-eligible person, who proposes to establish control of a Canadian business enterprise or to establish a new business in Canada unrelated to any other business of that investor in Canada, is required to apply for the approval of the Government of Canada for the investment. The approval decision is made by the Cabinet. In deciding whether to grant approval, the Cabinet is required to decide whether the proposed investment is likely to be of significant benefit to Canada. To make that determination, the Cabinet is required to take into account a number of factors, principally economic in nature. They include such matters as the effect on capital investment, employment, use of Canadian goods and services, etc. They also include consideration of the degree of Canadian ownership and participation in the proposed investment. Under the Act, the application is submitted to the agency, the Foreign Investment Review Agency. It reviews the application along with any other submissions from the investor, and following that, the application or a recommendation in respect of the application is prepared by the agency for the minister responsible for the Act. When the recommendation is satisfactory to him, it goes forward for Cabinet consideration and decision. The Act provides for a number of enforcement remedies, including the special remedy of what is commonly referred to as a nugatory order. Where an investment has proceeded without the necessary approval under the Act, the government is entitled to request a superior court to, and I'm quoting here, make such order as, in its opinion, is required in the circumstances to the end that the investment shall be rendered nugatory, not later than the expiry of such period of time as the court considers necessary, etc. While the term nugatory is not defined exhaustively in the Act, it is clear that it includes, among other things, an order for the disposition by any person of shares in a corporation or property used in carrying on a business. Investors typically seek FIRA advice, FIRA opinions, on the following three matters. First, whether the proposed acquisition of control involves a Canadian business enterprise. You could have a situation, for example, where the asset is rental real estate or mining rights or oil and gas rights. And the question arises, while that may clearly have commercial value, does the asset constitute all or substantially all the assets used in carrying on a business, which is the test for reviewability. Secondly, whether the proposed new business investment is related to a business already carried on by the investor in Canada. If the business is related to an existing business, then it won't be reviewable under the Act. Thirdly, whether the investor is a non-eligible person. In many circumstances, it is not clear or not clear at the outset. This can be the case where there is a significant degree of foreign investment in the company alongside significant Canadian shareholdings. There are provisions under the Act, and there are procedures in the administration of the Act to provide assistance on these questions. In connection with the last one I mentioned, that of status, the question of whether or not a person is a non-eligible person, the minister has authority under the Act to make a ruling, and he also has that authority in connection with the question of relatedness. The ministerial opinion on status is the highest level of comfort that is available under the Act. Not only does it address the legal interpretation question of status, which is a question to which the opinion of a lawyer might also be addressed, with perhaps some reservations which we'll come to. But the ministerial ruling also states in a binding way the position that the government will take in respect of that matter. Obviously, both of these questions, the legal interpretation question plus the government posture question, may be of critical importance to the investor. It might be cold comfort to the investor to know only that there are good legal grounds for saying that his status is Canadian controlled, if he does not also know that the government will be disposed to agree with that assessment. Conversely, if he doesn't know that the government will be disposed to agree, or if it's not known whether the government will be disposed to agree, it's perhaps a good idea to advise the investor of that element of uncertainty. In addition to the ministerial ruling, it is possible to seek some comfort from the agency itself. Traditionally, the most typical form of comfort has been the agency no action letter. This might more properly be referred to as a legal interpretation or legal no action letter. The letter typically either recites the facts of the matter or incorporates by reference the facts as outlined in the letter of application for the agency opinion. That letter usually comes from the investor's solicitor. The agency letter then goes on to say that the agency considers that, based on the facts, the proposed investment is not reviewable under the Act. The letter does not usually state the particular rationale for the legal conclusion. It concludes with a statement that the opinion is dependent upon the material facts having been fully disclosed. Traditionally, the letter has also stated that it is not binding upon the agency or the minister or the Crown. The agency has considered these caveats to be necessary because there's no express authority for these letters in the statute. Under a recent policy statement of the minister, I believe the agency is now authorized to issue letters on a basis that is binding on the agency. It doesn't say that they're also binding on the minister or the Crown, so I'm not at all clear on what the effect of their being binding on the agency is, since it is the minister who really has the administrative authority under the Act. For anyone who's trying to keep one eye on the printed text, I have moved, well, this won't be helpful because I've got different numbers. I've moved to topic bracket, 6 brackets, circumstances where an agency opinion would not be requested. It should be 16 pages into the lecture. We've mentioned the kind of comfort available from the agency. I'm eventually going to get to what it is that the lawyer for the investor can do, but I think this background is necessary to provide the context. Where it's not possible to place all of the relevant facts before the agency, or to ensure that all the relevant facts have been established, it could be expected that the agency would simply not be prepared to give any opinion or other letter of comfort. In such circumstances, the investor wouldn't ordinarily bother to ask for a letter from the agency. The investor's solicitor might well be able to have informal consultations with the agency which would determine that the agency wouldn't treat as relevant any types of facts other than those which the solicitor has already canvassed with the investor, so that the solicitor can, in that informal way, perhaps get some comfort for himself and for his client. In many cases, the timetable for a transaction simply won't permit the processing of an application for a ministerial ruling or an agency opinion letter. Again, that doesn't necessarily rule out some informal consultation with the agency. Another instance where there wouldn't likely be any request for an agency opinion would be the situation in which the solicitor realizes that the agency won't give a letter because the agency, in fact, takes a different view of the matter and would consider it to be reviewable. Again, in that situation, I think the question arises whether the solicitor has a duty to advise the client. I think clearly there the solicitor would have such a duty. In giving opinions on the Foreign Investment Review Act, there are a number of considerations which counsel should take into account. We've been talking about prior consultations with the agency. I think the questions to be asked here are the following. Have there been any consultations of this type? If there have they been formal or informal? What has been their outcome? If there have not been any consultations, why not? The next question to be asked is whether the facts as to prior consultation or lack of prior consultation need to be reflected in any way in the legal opinion. In some cases, it may be appropriate to indicate by implication that the opinion that is expressed is one that is based only on a consideration of the law and does not involve any prior consultation with the agency. This can be done by indicating that without any consultation with the agency, it is not possible to give any assurance as to the position the agency would take in the matter. There's an example of such a passage in the opinion in Appendix D. I'd like to turn to that for a moment. In Appendix D on page 2 of Appendix D, in the middle of the paragraph that starts in the middle of the page, and let me read the first two sentences there because the first sentence is relevant to another point we'll come to. This opinion concerned the question of whether the investor in question was a non-eligible person. There were significant Canadian shareholdings and a proposal that a foreign investor would acquire a significant position in shares with limited votes for up to 20% of the board of the company. The passage is as follows. The Foreign Investment Review Agency, which is the authority responsible to assist in the administration of the Act, is known to be interested in arrangements intended to ensure that a corporation is not non-eligible, and it is reasonable to expect that the agency would examine the arrangements if they are implemented. Since the agency has not published any interpretation notes or opinions bearing on their position in matters of this type, no assurance can be given without some consultation with the agency about the position it would adopt for administrative purposes. In another kind of case, it might be appropriate to allude simply to consideration having been given to the general practice of the agency in matters of the type being opined upon. There's an example in Appendix E. Simply the statement, in formulating our view, etc., we have taken into account, in addition to the relevant provisions of the Act, the provisions of the guidelines concerning real estate business issued pursuant to Section 4(2) of the Act. We have also taken into account our experience with the administration of the Act by the agency. Second consideration, the purpose of the opinion. Is the opinion being given to the investor simply for the investor's own assurance? Alternatively, is it being given to the investor for provision to some third party, such as a financier? In the latter case, a question may arise as to whether it is appropriate in the opinion to rely upon the relevant facts on the basis of an assumption without having a statement of those facts furnished by way of statutory declaration or established on some other basis. And speak about this a bit more in a moment. If it's desired to limit the range of persons who may rely upon the opinion or the use to which the opinion may be put, and I think this point has come up in some of the other talks as well, it's advisable to make that point explicit in the opinion letter itself or in an accompanying letter. There's an example in Appendix F of an excerpt from a covering letter. The relevant statement there was, We are providing this letter on the basis that it is available to you for use with the Foreign Investment Review Agency and in any proceedings under the Act, but it is not to be used otherwise without our consent. I mentioned the matter of establishing or assuming the relevant facts. In some cases, there may be difficulty in identifying all of the types of facts which are relevant. In such instances, it may be appropriate to refer to those facts in general terms. One of the situations I have in mind here is what you might call the negative fact. For example, in a consideration of the question whether a group control situation exists in connection with a corporate investor, there are certain factors that need to be considered. I'll mention the group control concept specifically. The question that arises where you have a number of investors in a corporation is whether some of them, including any that are foreign investors, can be treated as, or would be treated under the Act, as a group who hold control of the company. If there is an identifiable group and the foreign investor is included in the group, then the corporation would be regarded as would ordinarily be regarded as non-eligible. Where there's a possible group situation, it's necessary to consider whether there are any arrangements or understandings or practices amongst the possible members of the group which would constitute them a group. Basically, I think the test is whether they act together to exercise control in fact of the company. And control in fact is not a defined concept in the Act, so you can see that this starts to become a rather open-ended, potentially open-ended line of inquiry. Well, I think it's necessary to make some reference in an opinion to these kinds of considerations if a group question could arise. There's an example in Appendix D of one effort to deal with this kind of situation. In Appendix D on page 2, the second paragraph, that is the first full paragraph following the carryover. Let me read it. The provisions of FIRA dealing with the control of a corporation are stated in terms of the concept of control in fact. Accordingly, in order for any arrangement as to the control of EXCO to be effective for FIRA purposes, there must be no other arrangements, understandings, or practices which would enable any non-eligible person to participate in the control in fact of EXCO. For the purposes of the opinion expressed below, we have assumed that this would be the case. Now, I'm aware that it might be argued that this is tantamount to assuming the very matter to be opined upon, since the question on which the investor is presumably seeking assistance is, does the presence of the foreign investor involve the foreign investor as a member of a group and therefore cause the company to be non-eligible? I think there may be a parallel here, or an analogy here, between this kind of question and the sorts of subjective facts or questions of mixed fact and law that Emerson alluded to in his paper. The difficulty I have is in seeing how to do better than using this kind of general statement. One alternative, I suppose, would be to list all of those kinds of arrangements, understandings, and practices which might possibly be indicators of participation in control, and then state the assumption, or if there's to be independent confirmation, have it in a statutory declaration, that none of these elements exist in the case. However, that runs at least one risk that's typical of such lists. You end up discovering later on that the foreign investor has had some significant participation, through some practice not included in the list that you made up. So for the moment, at any rate, I'm more disposed to go with the kind of general statement that I just read. I should mention at this stage that in raising these various considerations, I'm not necessarily raising them in order of importance. The one I come to now is, I think, of central importance. I alluded to it earlier. A number of the central concepts in the Act are not defined with a high degree of precision. The principal concept of this kind is, of course, the concept of control in fact. In the almost 10 years in which the Act has been in effect, there has been very little litigation under the Act. The cases which have been decided do not yet amount to any substantial judicial mapping of the shape and reach of this concept of control. I usually consider it appropriate to allude in an opinion on FIRA to this relatively undeveloped state of the FIRA law. I believe it's a responsible course of action on the part of the solicitor to advise the investor that the law is in this condition, so that the investor can appreciate that the situation is different from one such as a typical corporate financing or business acquisition. I think it's also an appropriate comment or qualification for counsel to include in the opinion for his own protection. An example of this type of reference also appears in Appendix D. It's at the bottom of page 2. Maybe it's not at the end. Yes, it is. Starting at about 10 lines from the bottom of the page, where there's a discussion about the consequences that could ensue if the agency were to take an adverse position on the question of the status of the investor. It's mentioned that legal proceedings could be initiated then. If such proceedings were to be initiated, EXCO would have to establish to the satisfaction of the court that there is no participation by non-eligible persons in its effective control otherwise than as board members as described above. The relevant provisions of the Act are not designed to be specifically conclusive on this matter, and there are no relevant statutory guidelines. Accordingly, while we hold the view of the law which we have expressed above, no assurance can be given that our interpretation of the application of the Act in the circumstances of EXCO would necessarily be adopted if these matters were to become the subject of legal proceedings. In some cases, it's appropriate to express an opinion in terms of the writer's expectations as to what the agency is likely to do in a given situation. There's an example of this in Appendix C. Here the question was whether the agency would be likely in the course of the review process to require undertakings to achieve a level of Canadian equity investment as a condition of approval of the proposed investment. At the bottom of page 2, you'll see the text I have in mind here. There's a description of the FIRA review process. The FIRA review process operates on a case-by-case basis and involves an administrative assessment by the government with a high degree of discretion of a number of factors, principally but not exclusively economic. The process does not involve a system of reliance on precedents. Accordingly, any view as to the likely outcome of the review process in the case of a particular application cannot be more than a reasoned estimation concerning the exercise of administrative authority and should not be regarded in the same way as an opinion of law. The text then goes on to state what matters have been taken into account in formulating this statement of expectation. In considering the question which EXCO has asked, we have taken into account the significant benefit to Canada criteria for approval under FIRA and our experience with FIRA and the decision of cases under FIRA, together with information provided by EXCO, including information concerning the likely economic consequences of the expansion and the structure of the industry in Canada. then later on, in what may be a violation of the earlier suggestions as to how and when in the text you should state the opinion, the statement of expectation appears at some distance over on page 2, where we say towards the bottom of page 2, in our view, a FIRA application with supporting undertakings showing the potential benefits outlined above ought to have a very strong prospect of approval under FIRA without the necessity of a commitment by EXCO to make equity participation in its business available to Canadians. There's been discussion throughout the day on the question of format. In my experience, the format of opinions about FIRA tends to be derived from the format of legal opinions in other commercial transactions. The order of contents is usually as follows. First, the capacity in which counsel is providing the opinion, other preliminary matters such as the use to which the opinion may be put. Next, a description of the basic situation, for example, an acquisition transaction, which is to be addressed by the opinion. The nature of the FIRA question arising out of that situation, which is to be addressed. Next, the facts assumed or else established by appropriate documentation. Next, any background discussion of the law which is necessary as context for the opinion. A statement of the opinion itself. A statement of any qualification or other contextual comment which is considered appropriate to accompany the opinion. Obviously, the relative location of some of these items, such as the last three, can be rearranged in order to make the opinion clearer and more effective. Those are my remarks. I think we should now open the session to questions. Philip? The question is, in view of what appear to be pretty extensive qualifications in FIRA opinions because of the administrative nature of the Act and its processes, what is the real function for the client of a FIRA opinion? Well, as I mentioned, the highest level of comfort is a ministerial ruling. However, there are transactions where time doesn't permit the seeking of a ministerial ruling, and in that case, for example, the investor may well try to formulate a business judgment about the risk that would be involved in proceeding without a ministerial opinion. In that sort of situation, I think a lawyer's opinion can be helpful in showing what the situation is. I guess the difficulty is, and I think this was mentioned by one of the earlier speakers, the question is whether you need another lawyer to interpret the legal opinion. In one of these situations, the opinion that we had done actually came under the scrutiny of a fair number of other law firms. One law firm thought the opinion was right on, which was very gratifying. Another law firm thought that it wasn't worth a damn, and another law firm asked why we hadn't been able to give a stronger opinion, a question which rather baffled me. The only response I could make off the top of my head was that if I had been able to give a different opinion, I would have. And it subsequently emerged that even though they would have liked a stronger opinion from us, in our judgment, they thought our opinion in fact went too far.
Would you agree that it's a misnomer to use the word opinion? Really all one can do is express an informed guess as to how the agency will treat a matter. There isn't much law there.
Peter Beattie's question is, what business have I got calling these legal opinions when all I'm doing is engaging in an informed guess. Well, I'd like to take issue with that, but I have sometimes, I guess, described the process as not unlike, I think, what some of the Roman soothsayers did, which I think was peering into chicken entrails. I sometimes feel that we're in a distinct line from them.
But surely any legal opinion is merely an informed guess as to what a court or other tribunal will do. I don't know why the theory would be indicative in that regard.
The observation is that all opinions are informed guesses as to what tribunals will do. That question goes beyond FIRA, so I'll dodge it and see if Emerson wants to make any observation on the nature of legal opinions generally.
I don't think I have anything to add, Jim.
Are there any other questions or informed guesses or opinions? Thank you very much.